officers pulled him back out of the squad car onto the street. I believe you indicated that Mr. Floyd went to his knees on the ground and said thank you to the officers.
Okay, so they just started. They got the other paid witness here, the $10,000 witness, taxpayer paid for, to say what the government wants them to say.
Is that right?
Yes.
And it was at that point that the officers pushed him flat onto the ground into the prone position, and you saw Mr. Floyd kick with one leg while being pushed prone. Is that right?
Yes.
And I believe your testimony is that a reasonable officer could have interpreted that kick as being active aggression or active resistance.
Yes.
All right. I'd like to have you pick up your testimony there. Now, sir, just making some notes of the various times at which things occurred. I'd like to define sort of our restraint period, okay?
Yes, sir.
Now, based on your review of the body-worn camera footage and using Officer King's body-worn camera footage as a point of reference, can you tell the jury at what point in time, in your opinion, does the restraint itself begin?
Based on my review of the body-worn video, the restraint started at 20, 19, and 14 seconds.
And when does the restraint period end?
I believe it was 20, 28, and 43.
Wow, this guy's got a hell of a memory to remember seconds and minutes after watching all the videos. It's not like he knew this question was coming, right?
Seconds.
And sir, what is the duration then of that time period, the restraint period?
9 minutes and 29 seconds.
Remember, they keep saying 9 minutes and 29 seconds. They don't say when, which is relevant. When did Floyd stop resisting and appear to have passed out or become non-responsive and non-resistive? The whole time they were on him, he was resistive when he was conscious. But at what point did he become unconscious?
Your opinion, does defendant's use of force during that time period need to be reasonable within the entire time period?
Yes.
Have you been able to determine what force what specific force the defendant applied to George Floyd during the restraint period, as in his body position?
Yes.
Now, if I could publish Exhibit 17, you've already reviewed that, and I believe you indicated Exhibit 17 shows how the defendant was positioned on George Floyd. I'm going to ask you to give some additional detail in that regard based on your analysis, all right?
Yes, sir.
So at this time, I would like to display to the witness only Exhibit 254 for identification. So does this a 254 appear to be a composite of 5 different photos taken from offense materials in this case?
Yes, sir.
Can you just please, at a high level, explain what these different photos show, starting from upper left to the right and then down?
The upper left photo shows the beginning where the defendant and the other officers removed Mr. Floyd from the vehicle, the police vehicle, and were placing him in a prone position.
And the source of that photo?
I believe it was the building camera that was across the street.
Milestone?
Milestone, yes.
And then on the upper right?
The upper right picture depicts when the emergency medical services responded and they were about to
$10,000 to say what he's looking at on pictures. Wow.
put Mr. Floyd onto the gurney.
Okay. The lower portion of Exhibit 254 on the very left, what does that photo show?
That shows the defendant with his knee on Mr. Floyd's neck, and also his left knee on Mr. Floyd's neck and his right knee on Mr. Floyd's back.
Okay. The middle photo?
The middle photo shows the defendant with his left knee on Mr. Floyd's neck.
And then the final photo?
The final photo shows the defendant with his knee on Mr. Floyd's neck and lower neck area, as well as his right knee on the back of Mr. Floyd.
Right. And would the use of this composite Exhibit 254 assist you in explaining your analysis of the specific force used by the defendant upon Mr. Floyd during the restraint period that you've just defined.
Yes.
I'll offer Exhibit 254.
Any objection?
No objection.
254 is received.
I'm going to ask you to publish Exhibit 254. And now I'd like you to, just in a little more detail, if we could take Exhibit 254 and enlarge the upper left photo, first photo. All right, and again, this is the milestone footage, is that right?
Yes.
And the timestamp is 8:19 and 17 seconds, is that right?
Yes, sir.
Okay. Can you please explain to the jury what this shows relevant to your analysis?
Relevant to my analysis, it shows when the officers initially removed Mr. Floyd from the vehicle and they placed him in the prone position and they were utilizing body weight to control him as he was handcuffed.
And focusing on this individual, is that the defendant?
Yes, sir.
Right. And are you able to then make out the relative position of his legs relative to Mr. Floyd in that photo?
Yes, it appears that his knees are in a position where he's utilizing body weight, his left knee being in the neck area of Mr. Floyd and his right knee being in the back area.
All right, you can take that down and let's move to the next photo. I'm sorry. The photo in the lower left, so right beneath that. Yep, that's the one. Okay, first for frame of reference, is this taken from King's body-worn camera?
I believe so, yes.
All right, and we note the timestamp. It's at 20:19 and 27 seconds.
Yes.
All right, please describe to the jury what it is you see here.
Here, I believe the defendant's left knee is on Mr. Floyd's neck and his right knee is on his back area.
All right, if you could use the stylus and place a circle around the left knee of the defendant. And now
There's his neck.
on the right knee of the defendant. Okay. Now, based on your review, does this show the relative position of the defendant's knees during the entirety of the restraint period?
Yes.
If you could take that down. Okay. And now the middle photo is consistent with Exhibit 17, which you've already reviewed. But again, you see the positioning from a different angle of the defendant's left knee. Is that correct?
Yes.
And can you note anything specific about the position of his feet?
His feet are spread apart and on the ground.
Based on your experience in training, where would the majority of the defendant's body weight be given the position of the left knee, the right knee, and the feet?
That would be on his knees and pushing down from his knee area from his body.
He can't be pushing down because he's got his hands on anything to give him leverage. What does this guy not understand gravity? You can't push down his body weight, part of his body weight, because his feet aren't part of his body weight that are pushing down. It's only the weight above his knee, which means it's less weight than what he weighs.
And if you could take that down. All right. Now, if you could go to the upper right photo, this shows another moment in time, and the timestamp is at 8:27:49. This is from the milestone video. Is that right?
Yes.
Okay. What does this moment in time show?
It shows the defendant still on Mr. Floyd and the EMS personnel going over to try to survey what was going on.
This is shortly before the end of the restraint period that you've defined. Is that right?
Yes.
Now, were you able to observe
I'm gonna
the
bump this
relative position of the defendant using the milestone video from the start of the restraint period to this point.
Yes.
Did it change?
No.
If you can take that down, please. All right, and then if you highlight the last photo, lower right. Okay, and this is from King's body-worn camera, is that right?
Yes.
Timestamp indicates 20:28:43. This is at what you've defined as the end of the restraint period.
Yes.
And can you please describe to the jury what you see here relative to the defendant's leg positioning?
Yes, the defendant's left knee, again, is still on Mr. Floyd's neck, or neck area, and his right knee is on his back area.
If you take that down, please. And so based on your review...
So you know the defense should probably put up the photos that he showed to where his knee was on his back to contradict him. That's probably coming.
Of all of the camera footage, the defendant's body position with respect to that particular force did not change during the entire restraint period.
Correct.
If you're paying him $10,000, you probably want to keep him on a stand a little bit longer to get your $10,000 worth. It doesn't make sense to pay him $10,000 and only have a few questions. This guy's not
Sir,
a good
if you could take
expert.
that down, please. I ask you if the defendant, if you observe the defendant on a body-worn camera apply any other type of force upon George Floyd other than what you saw with respect to his legs and body weight.
Yes. Towards the beginning of the original restraint, the defendant used his right hand, and he was appeared to be attempting to use a pain compliance on Mr. Floyd's left hand.
This time I'd like to publish Exhibit 255, which I believe is in evidence.
He's correct. He did have him in a wrist lock, which is an approved technique
Using
right
Exhibit
there.
255, sir, can you please explain to the jury what you mean, and if the stylist would help, you can use that.
Yes. So here you can see the defendant's right hand grasping the fingers of Mr. Floyd's left hand.
What would you have him do? Not hold anywhere? This is a control hold. It's not necessarily a pressure. I mean, it could be called a pressure point. He's not breaking his wrist or wristing. He's using something for leverage. He can't get his hands in between, and that's what he should be asking him. Is it proper to put your hands in between the handcuffs so they can get pinched or cut off? You know, people know how to cut a finger off or cut hands with handcuffs by twisting them in a circle. Cons are trained how to do that to officers. So you don't want your hands in the cuffs. You notice this officer's below the cuffs and he's above the cuffs. Where else is he supposed to grab? Should he grab here? And again, I'm not sure whether this is being portrayed as he shouldn't have done it. They're just trying to say he was using more force. And again, I can see George Floyd's neck right here.
You use a
And
term.
squeezing him.
I'm
It
sorry.
appears to be squeezing him.
And you use that term pain compliance. Can you please describe what that means?
Yes, so pain compliance is a technique that officers use to get a subject to comply with their commands. As they comply, then they are rewarded with reduction of pain.
And how would this positioning induce pain?
This can induce pain a couple of ways, either by squeezing of the fingers and bringing the knuckles together, which can cause pain, or also basically pulling the wrist into the handcuff, which can cause pain as well.
And you can see on Exhibit 255 where there's where Mr. Floyd is handcuffed.
Yes.
Can you please put a circle around that? Okay, so is it your testimony then that the drawing of the fingers down and the wrist down towards the handcuffs could induce pain?
Yes, especially because the handcuffs were not double locked. Double locked meaning that they could continue to ratchet tighter as the person moved.
That has nothing to do with this pain compliance. This officer cannot make those handcuffs get tighter by pulling where he pulled. The defense should make him clarify that and make him look like an idiot.
Were you able to hear instances of what you recognize to be ratcheting during your review with body-worn cameras?
Yes.
Right, so
Yeah, ratcheting happens when the suspect is continuing to fight and resist, so the officers have the inability to double lock because they're still trying to control the actively fighting suspect. So it's not the officer's fault they didn't double lock. The resistive actions of the suspect caused them not to double lock. And the resistive action, wiggling, moving, and fighting officers while they were trying to control him caused the handcuffs to lock. It's not the officers wanted to do it to increase pain compliance. That's kind of what he's leaving in the wiggle room to confuse the jury.
In the principle of pain compliance, if I'm to understand your testimony, you would inflict pain for the purpose of having the subject obey your command.
Yes, comply.
What if there's no opportunity for compliance?
Then at that point, it's just pain.
You again observed the entirety of the body-worn camera footage. Did you see whether the defendant discontinued the use of this pain compliance technique during the restraint period that you've defined?
Yes, I did, and no, he did not.
If you could take that down, please.
Since he had to answer two answers, that was not a proper question. He should have asked one, let him answer, and then ask the other one. He answered two questions, which shows it wasn't a proper question.
Sir, you previously testified about the Graham versus Connor factors, the three different factors you used in your analysis. Is that right?
Yes, sir.
In your review of Minneapolis Police Departmental policy, does the Minneapolis Police Department integrate these Graham-Connor factors into its policy and procedure manual?
Yes.
Now, you testified as to these factors, at least one of them, of the actions, what happened prior to the restraint period. I'd now like you to focus on the restraint period itself, okay?
Okay.
And if we could publish Exhibit 217, I believe it's page 2, and highlight the 3 bullets in the middle of the page. All right, this is from the Minneapolis Police Department Use of Force Policy and Procedure Manual, Section 5-300 series, is that right?
Yes.
And you see the different Graham versus Connor factors outlined here that you previously testified about, true?
Yes.
Now, you've already spoken as to the first factor, the severity of the crime at issue. Did that change during the restraint period?
No. The crime was still that Mr. Floyd was in possession of a fake $20 bill.
So I'd like you to focus then on the second factor, that is whether Mr. Floyd posed an immediate threat to the safety of the officers or others at the time during the restraint period.
No, he did not.
And why not?
Because he was in the prone position, he was handcuffed, he was not attempting to resist, he was not attempting to assault the officers, kick, punch, or anything of that nature.
Did he ever communicate an intent to do so?
No, he did not. I didn't hear any verbalization of any threats towards the officers.
Did he ever indicate whether or not he had the ability to do so?
No, he did not.
Can you comment as to the number of other officers on the scene present at the time and how that would relate to any opinion you have regarding whether Mr. Floyd presented a threat?
Yes, so another factor that's considered when evaluating a use of force is the number of officers versus the number of subjects. In this particular instance, there were actually 5 officers on scene, 3 officers that were using body weight on Mr. Floyd, and there were 2 additional officers that were on scene as well.
And
He failed to mention that there was also several unruly, loud, verbally abusive crowd gathering. I guess he kind of didn't see that in the video.
in terms of the threat, there's a descriptor here, and that is it needs to be an immediate threat. Is that right?
Correct.
And so, on your analysis, Mr. Floyd, in order to pose an immediate threat, would be able to presently cause some sort of harm. Is that correct?
Yes, immediate meaning it is happening right now.
Now, focusing on the third factor, and that is whether Mr. Floyd was actively resisting or attempting to evade arrest by flight. Could you describe to the jury your analysis as to that third factor?
Based on my analysis, Mr. Floyd never was not actively resisting at the time that he was in the prone position, nor did he communicate to them that he was attempting to resist or evade them.
Now, are you familiar with the concept of proportionality? You could take that down, please.
Yes, I am.
Can you please explain the concept of proportionality as it relates to the use of force to the jury?
Yes, so proportionality basically means that an officer is only allowed to use a level of force that's proportional to the seriousness of the crime or the level of resistance that a subject is using towards the officers.
Are you familiar with a graphic known as a force continuum that can be used to illustrate this point?
Yes.
And does the Minneapolis Police Department use a similar item of force continuum to illustrate this point to its officers?
Yes, they do.
And if I can show Publish Exhibit 110, is this the force continuum that MPD uses, a version of it?
Yes, sir.
All right. Now, if you could take that down, please. Exhibit 919 is a demonstrative exhibit that can be used to illustrate this concept, and I'm going to ask that Exhibit 919 be published at this point.
No objection.
You may.
All right, sir, we're publishing Exhibit 919, and what I'd like you to do is sort of walk the jury through the concepts of proportionality using 919 demonstrative to explain. You would begin, please.
Okay. If you look on the far left, you see the subject's behavior. It starts off being active aggression, goes down to active resistance, then passive resistance. We'll start at the top being active aggression. So if the subject's behavior is active aggression, then depending on the severity of it, if it could cause serious bodily injury or death, then an officer is allowed to use deadly force. Moving down, if the subject's actions don't meet the deadly force threshold, then an officer is allowed to use a baton. Also, stunning strikes and unconscious neck restraint. Stunning strike is basically a type of force that an officer can use when he is being assaulted to temporarily stun the person so that they can try to control them. Obviously, also the unconscious neck restraint, I believe, is when an officer uses a neck restraint or a carotid restraint to temporarily make the person unconscious. Continually moving down, as the subject's behavior is less aggressive, moving closer to active resistance, you see an officer is allowed to use a CED, which is a conducted electronic device, or what you might be known to know as a taser. And also they can use a chemical aerosol, which you would also maybe know as a pepper spray. If the subject's behavior doesn't meet that threshold, then an officer can utilize a distraction technique. A distraction technique is typically similar to a stunning strike, but basically a distraction technique is used to temporarily stun the person in order to follow up with another technique to possibly take them down to the ground or use to control them as well. Obviously, you have a control takedown as well, and a conscious neck restraint to control the person based off of their active resistance. Moving down, if the subject's behavior is passive resistance, then an officer can use a joint manipulation or a pressure point or escort holds, and these are probably the most commonly used types of force when officers are in the field. And then lastly, you have verbalization and just an officer's presence when the person is complying or, possibly passively resisting just verbally.
And if no resistance is offered?
Then just your presence.
Sir, do you have an opinion to a degree of reasonable professional certainty to how much force was reasonable for the defendant to use on Mr. Floyd after Mr. Floyd was handcuffed, placed in the prone position, and not resisting?
Yes.
What is that opinion?
My opinion was that no force should have been used once he was in that position.
I see on this continuum that...
So how can you use no force when the subject has been fighting for the last 10 minutes, refusing to get in the car, trying to get away, saying he can't get in the car, pushed his way out of the car, and they finally got him stabilized? Your answer is no force. And you've already testified that touching someone or putting your hands on is force. So in your expert opinion, as soon as they got him down, all officers should have just stood up and not used any force and just used their voice. Is that what you're telling us? That's freaking ridiculous.
That phrase, deadly force. Is deadly force defined?
Yes.
Is it defined in Minneapolis Police Departmental policy?
Yes, it is.
At this time, I'd like to publish Exhibit 216 of deadly force is, beginning at force which the actor uses.
Yes. Force which the actor uses with the purpose of causing or which the actor should reasonably know creates a substantial risk of causing death of great bodily harm.
I'd like to now republish Exhibit 254, the composite. Certainty whether the force used, as shown in Exhibit 254, whether that force being applied then for the restraint period, which you've defined as 9 minutes and 29 seconds, would constitute deadly force.
Yes.
And what is that opinion?
That it would.
Why is that?
Because at the time of the restraint period, Mr. Floyd was not resisting. He was in the prone position. He was handcuffed.
That's incorrect. If I was the defense, I'd be like, are you telling me the whole time that George Floyd was in the prone position, he was not resisting? Because you can show the video where he's trying to get up. He's picking his head up. He's turning. He's twisting his body. That's what caused the officers to get on him, is because he was resisting once they got him on the ground.
He was not attempting to evade. He was not attempting to resist. And the pressure that was being caused by the body weight could cause positional asphyxia, which could cause death.
Is positional asphyxia a known risk in law enforcement?
Yes, it is.
How long have the dangers of positional asphyxia been known?
At least 20 years. I can recall a Department of Justice memo from, I believe, 1995 that discussed it, and I know that I was trained on it in 1995 as well.
And the risk or the danger of positional asphyxia, the worst outcome is death, is that right?
Yes, sir.
And when we talk about positional asphyxia and the risk, is that risk increased with the increase of pressure on the subject?
Yes, so positional asphyxia can occur even if there is no pressure, no body weight on a subject. Just being in that position, and especially being handcuffed, creates a situation where the person has a difficult time breathing, which could cause death. When you add body weight to that, then it just increases the possibility of death.
And what additional weight did you see in your analysis here?
The defendant's body weight, as well as the two other individuals, the two other officers.
One of the other officers appeared to be pressing down on Mr. Floyd.
Yes.
Was that Officer King?
Yes.
And what was Officer Lane doing?
He was holding his legs.
You can take that down, please. Sir, in applying the rules of use of force and use of reasonable force, it's the officer has to consider the totality of circumstances. Is that right?
Yes, sir.
And one of the circumstances can be the location. That could be important. Is that right?
Yes.
And are you aware that there was a group of bystanders who eventually began to watch the defendant and the other officers use force on Mr. Floyd?
Yes.
Now, sir, in your experience with the Los Angeles Police Department and in the areas you were patrolling, have you ever had to use force or apply force or handcuff a suspect in the view of bystanders?
Yes, sir.
Have you ever had to handcuff an unwilling suspect or subject in the view of bystanders?
Yes, sir.
Have you ever had to do so in the presence of a hostile crowd?
Yes, sir.
Could you define a hostile crowd in that context?
I would define hostile crowd in the situations I've been in where the crowd or members of the crowd were threatening and or throwing bottles and rocks at us, at the police.
Have you had that experience?
Yes, sir.
On more than one occasion?
Yes.
Okay. So if I could publish Exhibit 184, I'm getting back to the circumstances of this case. This appear to be the bystanders that were gathered watching the defendant apply force to Mr. Floyd.
Yes, it does.
When you reviewed the body-worn cameras, did you see anybody throw any rocks or bottles?
No, I did not.
Did you see anyone physically attack the officers?
No, I did not.
Did you hear foul language or name calling?
There was some name calling, yes, but and some foul language, but that was about the most of it.
Did that factor into your analysis?
No.
Why not?
Because I did not perceive them as being a threat.
And why is that?
Because he wasn't there and he wasn't in danger and he wasn't dealing with it. If he was there, I guarantee you, he would have been concerned about that. That's like saying crowd control is at a riot, and because the crowd isn't throwing rocks or violence, all the officers should just leave because there's no problem, right? I mean, basically this testimony is, unless they're throwing rocks and bottles, they're not hostile. Really?
Because
Why don't you explain that to the officers that were sitting in their car writing paperwork and a person walked up and fired around and killed them? No, they weren't hostile. They were just walking.
they were merely filming, and most of it was their concern for Mr. Floyd.
And in terms of the proportionality in the force continuum, is the officer able to increase the use of force on an individual based on the conduct of some third party over whom the subject has no control?
No, the officers can only use force based on the subject's actions.
But you acknowledge that loud noise and name calling can in fact be...
I think that's inappropriate. I can use force if I'm going in on a building where there's hostages. I can grab a hostage and use force to remove them without any actions from them at all. So to say it's only because of the suspect's action is absolutely incorrect.
Distracting.
Yes, it can be.
What does an experienced and trained officer do in the face of that sort of distraction?
They continue to assess and reassess their force, or they would attempt to lower any type of threat level that they may perceive.
Now, based on your review of the offense materials and the records, as of May 25, 2020, how long had the defendant been a Minneapolis police officer?
Approximately 19 years.
And if we can call out, publish Exhibit 203, 866 hours
Yes.
of paid training. Prepare the defendant for this distraction.
Absolutely.
You take that down, please. Now, sir, but you do acknowledge that it would be possible for a loud group, to distract a defendant from being attentive to George Floyd. Is that right?
Yes.
Do you believe that occurred?
No, I do not.
And why is that?
Because in the body-worn video, you can hear Mr. Floyd displaying his discomfort and pain, and you can also hear the defendant responding to him.
At this time, I'd like to publish Exhibit 47 and bring us to the body. That's the body-worn camera footage of Lane. Bring us to the point of 20. This time, I'd like to publish that and play that section for the jury.
That's moving. My stomach hurts. My neck hurts. Everything hurts. There's water or something. Please. Please. I can't breathe out for it.
Talking,
They will kill me. They will kill me, man.
takes a heck of a lot of effort.
Notice the body-worn camera that was knocked off the officer because of George Floyd's active resistance.
Come on, man.
All right. Is that the exchange that you testified to of the defendant responding to statements of Mr. Floyd?
Yes, sir.
And sir, approximately how long did the defendant continue to restrain George Floyd after the exchange we just heard?
I believe 6 minutes.
Okay. Thank you. I have no further questions.
Wow, $10,000 testimony there. All right, let's see if he gets defensive and doesn't know as much. Let's see if he can answer it quick. Since this is the expert, this is the defense really needs to go after this guy hard.
I may have just a moment to get set up here.
Now remember, the defense didn't know what he was going to ask him, so he's kind of having to respond on the fly, write down, and get his cross ready within the few seconds you saw, because he doesn't know what the prosecution is going to ask him. He doesn't get to spend hours with him like the prosecution does, and he doesn't get to pay the guy. The prosecution gets to pay him. Actually, the taxpayers, but
Good morning, Sergeant Steiger.
Good morning.
Thank you for being here. Did you enjoy the rain last night? A
Yes.
little different than California, right?
Yes, we don't get that much.
Right. Sergeant, I have a few questions
Little
first and
bonding.
foremost about your experience. Have you ever previously testified in any court or in any state or in federal court as an expert on the police use of force?
No, I have not.
wow, $10,000, and he's never testified in a court. They also ought to ask him, has he ever testified? Well, yeah, he's probably testified for the defense too. I'd like to know what his...
Have you ever been qualified by any court of competent jurisdiction on as an expert in the use of police force?
Yes.
Where?
In Los Angeles during a trial of use of force that I was the investigator for.
Okay. Is that the only time in that case?
Yes.
And you are here in your own personal capacity, correct?
Yes, sir.
You are not here as a representative of either the Los Angeles Police Department or the Office of Inspector General, correct?
Correct.
The training that you've experienced and that you have conducted, that has all been by the Los Angeles Police Department, correct?
No.
So the training you received to become a police officer, it's primarily conducted by the Los Angeles Police Department, correct?
Yes.
You may have gone to some outside vendor training, but those vendors had to be approved by the Los Angeles Police Department, right?
Yes.
Meaning the training that you attended outside of LAPD stuff would have to be consistent with Los Angeles Police Department's policies.
Not necessarily, no.
Okay.
They have to be in compliance with California Post.
Okay. Now, you would agree that the policies of the Los Angeles Police Department are their policies, correct?
Correct.
And the policies of every police department are going to be different to some degree.
To some degree, yes.
And some police departments may authorize a particular form of force while others don't, correct?
To a certain extent, yes.
And that is a question of the reasonableness of that type of force. One department may say this is not a reasonable use of force, and another department may say this is a reasonable use of force.
Based on my training experience, every agency that I've seen based their use of force policy on Graham versus Connor, so it's pretty standard.
Right. But in terms of the actual tactics of the use of force.
It's not standard because do you know agencies that allow the neck restraint and agencies that don't? Yes. So therefore, some agencies, even though they're complying with Graham versus Connor, agree that the neck restraint is reasonable and others do not, right?
Right? So a department may authorize the use of a particular tool, and another department may not authorize that tool.
Correct.
Use of, and thus they're both uses of force or potential uses of force, and the instruments to use that force may be different.
Yes, but they all have to fall into the objective reasonableness standard.
Understood. But one department could determine that that type of an instrument or that technique is within the reasonableness, objective reasonableness standard, while another department may not.
Correct.
So there can be, it's another way of saying reasonable minds can differ.
Correct.
Now, you testified that you have been a trainer for the Los Angeles Police Department in terms of their tactics, correct?
Yes, sir.
So when you talk about your training experience, are you doing it from like a teacher, you're teaching, lecturing, that type of standpoint, or are you doing the training on the mats, training the techniques, or both?
Both.
You've never been trained by the Minneapolis Police Department, correct?
No, I have not.
All right. But upon being hired in this case, you received a lot of materials in this case, right?
Yes, I did.
You received an extensive amount of Minneapolis Police Department training materials, right?
Yes.
And you received investigative reports, right?
Yes.
From the Bureau of Criminal Apprehension, correct?
Yes.
And you received video cameras, correct? Or videotapes, correct?
Yes.
And you received materials within the training materials that also contained like videos or examples and illustrative type of materials as part of the training materials, right?
I don't quite understand.
Well, let me rephrase it. Sometimes in a PowerPoint presentation, there may be a video embedded in that PowerPoint presentation. And that video is an example of a specific move, or it may be training exercises or these scenario-based trainings. Did you see all of those?
No, I did not. I wasn't able to, because most of the PowerPoint presentations were in a PDF form, so I was not able to view the videos.
Okay. So you've not seen the training videos prepared by the Minneapolis Police Department?
No.
But all of this material that you have received is, in fact, what you used in part to form your opinions in this case, right?
Yes, sir.
You relied on those materials to a certain extent.
Yes.
And some of those materials were completely irrelevant to this case, agreed?
Yes.
Such as the use of the taser, right?
Yes.
Such as the mounted patrol unit, right?
Yes.
But you received other information that was informative and had an effect on your analysis in this case, agreed?
Yes.
So those training materials were an important part of how you came to form your opinion.
Yes.
Now, you ultimately prepared a written report, correct?
Yes, I did.
And in your written report, you detailed your opinions and findings on the case, correct?
Yes, sir.
And you also made an exhibit of the materials that you reviewed, right?
Yes.
Now, would you agree that your report in total is 461 pages?
Yes.
Right.
Wow, 451 pages divided by 10,000. What do we get per page?
I have it here, right? 461 pages.
Yes.
Of the 461 pages, 26 pages constitute your opinions, right?
Correct.
And from page 27 to 461, this is a list of the materials that you reviewed in preparation of this case.
That I received.
That you received.
Yes.
And you reviewed some, but not all of these materials.
Correct.
All right.
That's a good point. I mean, really? You came in and reviewed all that, and you automatically assume that, man, he's making a lot of conclusions. But because he's an expert, he gets to have an opinion.
Ultimately, what you concluded that you received a total of 5,737 different training materials or items to review.
I don't know the exact number, but
If the last number in your list is 5,737, would you dispute that?
I would have to look at it, but yeah, I would.
Wouldn't disagree.
I wouldn't disagree.
All right. In addition to your analysis, you're using and relying on your own training, right?
Yes.
Your own experience as a police officer, right?
Correct.
your experiences doing both peer review of use of force with the Los Angeles Police Department and your investigation of uses of force, correct?
Correct.
And you ultimately submitted your report to the state.
I mean, think about this. The Attorney General of the state of Minnesota has the entire law enforcement community at his grasp, and he can pick any expert he wants that's actually working in Minnesota and familiar with Minnesota law. And he has to go all the way to LA to find a black expert and pay him $10,000. Wow. Man, if I was on the jury, I'd be like, really?
Of Minnesota on January 31st of this year, correct?
I believe so. Yes, that's correct.
Since you have submitted your report, have you received any additional information, investigative or otherwise, about this case?
No.
So any training materials that came to us subsequent to January 31st, any investigative information that was received, you've not had an opportunity to review that, right?
Correct.
Oh man, that's tough. I can't believe the DA would not provide him more information after he did his report. Say, hey, we just found this out, blah, blah, blah. I find that hard to believe.
Since submitting your report, it's fair to say that you've also had several conversations with prosecutors in connection with this case, correct?
Correct.
I believe that you met with prosecutors or conversed with prosecutors on February 1st of this year, March 3rd of this year, March 11th of this year, and April 3rd of this year. Would you dispute me if I told you that those were the dates?
I mean, I would have to look at my calendar, but no.
Okay, I was pausing to redo my screen, and they said something about a sidebar. Now, a sidebar, I've been calling it kind of an objection. A sidebar isn't an on-the-record objection. It's kind of like, usually it's procedural, but it can be an objection kind of out of the scope. Now, the judge will get pissed if you have a lot of these freaking I'll let this run because while they're doing this, they're not going to be talking. So, if somebody calls for a sidebar, that means the two attorneys normally walk up to the side of the bench. If somebody asks, is these sidebars put on the record? They are not put on the record. These are off-the-record communications. Just like when the two attorneys go into the judge's office and discuss something. That's not on the record. They don't have somebody court reporting that. Now, they may put a document that says what they did, but it's not.
So I guess in addition, you had an additional meeting with prosecutors after court last night.
Excuse me?
In addition to the dates I've already referenced, you had an...
Oh! That's why the defense wanted to do that. The prosecution did not disclose that they talked to him last night. And he just said, are these the only meetings you had? And he said yes. And before he could catch him in a lie, the defense said a sidebar. We met with him last night. We haven't had a chance to discover it. And that's how you get around discovery. I'm going to do a separate video on discovery, exculpatory, and why DAs can hide shit. But we'll go ahead and go on here.
Some additional trial preparation yesterday with the prosecution, right? After your testimony?
No, we had a brief conversation, but no trial prep.
Okay. You and I have never met or spoke, right?
Correct.
But you're aware that prosecutors give me summaries of those meetings?
Yes.
So you also testified yesterday that in your role with the Los Angeles Police Department and the Office of Inspector General, thank you. You've reviewed thousands of use of force cases, right?
Yes.
And it's fair to say that those cases range in terms of the use of force, right? The types of force used are very variable.
Correct.
Some cases may involve whether an officer should have punched a person, right?
Correct.
Some may involve whether they should have used a particular technique or not, a taser, for example.
Correct.
Some involve the use of deadly force, correct?
Correct.
But they're not all, these thousands of cases are not all deadly force or resulting in the death of an individual, right?
Correct.
And in fact, the vast majority of these are based upon like civilian complaints perhaps, or...
He should follow up. How many use of force have you evaluated where it did come from deadly force? That should be a good question to follow up.
a sergeant's review of a use of force, right?
Sergeant's review, a sergeant's investigation, yes.
Right.
Not civilian complaints, but primarily as our sergeant's investigation.
So in the Los Angeles Police Department, it's similar to the Minneapolis Police Department. If an officer uses force, there are certain types of force they have to report to their superior, correct?
Correct.
And then the superior, the sergeant, will review and investigate that use of force, correct?
Correct.
And then that process, from once that report is completed, you were on the panel of people that reviewed that investigation.
On certain occasions, yes.
So again, I mean, in your capacity of reviewing the use of force, you would agree that Graham versus Connor is the standard,
Correct.
right? It is the universal standard for all police officers in the United States, right?
To my knowledge, yes.
And that's because
It's federal law. It's from the U.S. Supreme Court.
it comes from the United States Supreme Court, right?
Yes.
Kind of the highest law making or the highest court in the land, right?
Correct.
And that's the standard that the Office of Inspector General uses,
It uses the Los Angeles Police Department's use of force policy.
which also includes the Graham versus Connor standard.
Correct.
Now, in terms of Minneapolis, that's the same standard we use here.
Yes, it is.
Right. And that's embodied in the Minneapolis Police Department's use of force policy 5-303, correct?
I don't know the exact number, but yes, I believe so.
Now, the Graham versus Connor factor, if I just may have a second. Factors. And you've done thousands of use of force reviews. You're comfortable discussing Graham versus Connor?
Yes, I am.
Okay. I'd ask the...
Sure.
Okay, another sidebar. I'm not sure why. You're comfortable discussing the last question was you're comfortable discussing it, and you said yes. I'm not sure what the objection would be. Maybe that wasn't a
Department policy that incorporates Graham versus Connor, correct?
Correct.
And within the Minneapolis...
Let's hear what his first question is.
So again, you've reviewed the Minneapolis Police Department policy that incorporates Graham versus Connor, correct?
Correct.
So it must have been that he was improper questioning. I don't know why he just didn't object to it and let the objection stand or be overruled. But for some reason, they went over to like a sidebar.
And within the Minneapolis Police Department policy... Within the Minneapolis Police Department policy, I'd ask the court to, I would like you to publish Exhibit 106. I have 106 up. There is, at Exhibit 106, there is the incorporation of Graham versus Connor.
Yes.
All right. Now, the authorized use of force in the state of Minnesota exists primarily from a state statute, correct?
Yes.
And then that state statute, in terms of the police department policy, has to be consistent with the Graham versus Connor factors, right?
Correct.
And it's fair to say that there's more to the analysis of Graham versus Connor than simply the severity of the crime, the immediacy of the threat, or the act of resistance, right?
Yes.
In fact, what the ultimate police department policy says here is because the test of reasonableness under the Fourth Amendment is not capable of precise definition or mechanical application, its proper application requires careful attention to the facts and circumstances of each particular case, including those three factors.
Correct.
Right? Not limited to those three factors, though.
Correct.
After the policy discusses those three factors, the policy goes on to read that the reasonableness of a particular use of force must be judged from the perspective of the reasonable officer, correct?
Correct.
On the scene, correct?
Correct.
Rather than with the 20/20 vision of hindsight, right?
Right.
And the reason that becomes important is this next paragraph, which reads, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Agreed? That's what it
That's what it
says?
says. Yes. You're correct.
And this is the Minneapolis Police Department policy.
Correct.
And the reason
And
it
then
says that is the Supreme Court knows and understands that it's unfair to make an officer accountable to such a standard that people get to sit in an office, 20 lawyers get to sit in an office 5 weeks or 6 months later debating this, and they get to come up with a reasonableness, but it's unfair to hold an officer that standard because he has to make these in the middle of the night, rapidly evolving situations. His life and safety is in jeopardy, and there's a multitude of factors that is being comprehended very quickly or calculated very quickly, and they have to make split-second decisions. So the Supreme Court wants to give officers basically what's called a large umbrella of protection and leeway that, look, what is reasonable to an officer that's smelling and that's active and that's dealing with fight or flight and resisting and has a gun and maybe weapons involved and drugs and suspects are trying to get away and there may be multiple suspects and there's lights and there's sirens and there's you have to give them leeway to where what they did, was it malicious and did they think about it and was it intentional? And if it isn't, then it usually falls into it was reasonable.
Concludes by saying that the authorized use of force requires careful attention to the facts and circumstances of each case. Agreed?
Correct.
All right. So ultimately, the analysis of the objective reasonableness of any case has to be a consideration of all of these thoughts that are contained within the policy.
If they apply, yes.
And this is not an exclusive list of factors that apply, right?
Correct.
Because ultimately, it's what's called the totality of the circumstances
Yes.
event, right?
Yes.
So we have to look at the entirety of everything that's going on, right?
Yes, we have to look at the subject's actions as well as the officer's actions. And typically during my analysis, I look at the actions before, during, and after, what the officer knew at the time, and things of that nature.
And sometimes the use of force is instantaneous, right?
Sometimes, but not in this case. I didn't believe so.
Understood. But sometimes the
Not responsive. He's trying to push his agenda. He added something that he didn't ask for, and now he just added something again. The attorney needs to lock him down really quick. Ask an answer. Please, it's non-responsive to my question.
use of force is instantaneous.
Sometimes, correct.
Right. I shoot a gun, that's a very fast action, right?
Correct.
I punch you in the face, that's a quicker type of a reaction.
Correct.
I tase you, it's a quicker reaction. It's just inherently a fast action.
In some cases, correct.
And ultimately, one of the things you said yesterday was that you concluded that this was an excessive use of force, right?
Yes.
That's not the standard, is it? The question is whether it is an objectively reasonable use of force, right?
Correct.
Oh, good question. He said it's excessive. Is it objectively reasonable? Now, normally, if you say it's excessive, you're implying that it wasn't reasonable.
Now, when we review an authorized or whether a use of force is authorized, there are sort of layers to that analysis. Would you agree with that?
Yes.
All right. And I'm going to kind of start from the out and then work my way in. There's the general training that an officer has and his experience or her experience, right?
Yes.
There is kind of a mid-level of surrounding circumstances, right? Like, what do we know about the geography? What do we know about the neighborhood? What do we know about the people involved, right?
Yes.
And then there's the direct kind of layer, which is what's the type of force being used? How long is it being used? What are the subject and the officer's?
I've never heard it explained that way. If I was the expert, I wouldn't let him define it that way. I'd say if that's the way you're defining it, I could probably agree that that's a reasonable definition of it, but I've never heard those layers in any type of training.
Actions and reactions, right?
Yes. Seriousness of crime, things of that nature, yes.
Yep. So, under the reasonable officer standard, we have to take into consideration the officer's training, right?
Yes.
We have to take into account his or her personal experience, right?
Yes.
Size.
We have to take into account tactical advantages or disadvantages, right?
Correct.
We have to take into account scene security.
Yes.
We have to take into account the safety and security of our police, our partners, right?
Yes.
We have to take into account the public's safety, right?
Yes.
We have to take into account the location, generally speaking. Is this a high crime, moderate crime?
Now, because he's the defense, he's probably not going to say we have to take in the subject in our custody's safety. He's probably not going to say that, but the prosecution will come back and say it.
Or low crime area, right? We
Yes.
take that into account. We have to take into account the specific location, meaning am I in a middle of a busy intersection where buses and cars are driving by, or am I in someone's yard, backyard, right?
Yes.
We have to take into account
Even in someone's backyard, you got to worry about the owner coming out. If they have a dog, if they let the dog out, if a neighbor's going to think you're a burglar. So there's still threats in the backyard. It's just not like it was on a busy street with cars spinning by. That's what he's kind of getting at.
de-escalation possibilities, right?
Yes.
So you've seen, and you discussed a little bit yesterday, the Minneapolis Police Department, I'm sorry, we can take this down. The Minneapolis Police Department's critical decision-making model, right?
I don't believe we discussed that yesterday.
But you reviewed that,
Yes.
and you understand that what an officer is supposed to do is kind of go through this cycle process, taking in information, right?
Constantly evaluate.
Assessing the risk, the threat, deciding is it lawful for me to do this? How do I react? Ultimately with the goal of keeping everybody safe, right?
Yes, that's a pretty standard thing to continually reassess as you are using force.
Right.
It may be standard, but it doesn't mean that some officers are better at it and some aren't. And depending on the number of factors and the number of distractions and the things that are going on in this rapidly evolving situation, doesn't make it easy to follow every stinking policy and to make sure everything is perfect, because you're constantly processing all this new information and trying to adjust and adapt.
Reassessment is a specific tool,
Yes.
and that's common to police officers, right?
Yes, sir.
You have to take into account that sometimes incidents or interactions with a citizen are benign at best, right? They're not risky in any sense.
Correct.
But that not risky situation can very quickly become a very risky situation. Agreed?
Agreed.
And there are certain circumstances that officers, they walk into knowing that this could be a higher risk situation, right?
Yes, depending on the nature of the call, things of that nature.
So, for example, domestic assault calls have a high risk, right, to an officer.
Yes, just like a robbery or
Just like a robbery,
Shooting.
a shooting. Lots of situations that officers are expected to go into, they go into with
He's letting a witness kind of not really answer questions, but kind of give information. Normally you wouldn't do that, but because the prosecution knows that he's his witness and he's paying him, he knows he's going to say things that helps the prosecution like he's been doing.
with a heightened sense of awareness. Agreed?
correct.
And sometimes an officer will walk into a situation, have no sense of risk or no sense of concern, but they have to prepare for the unexpected. Agreed?
I wouldn't agree with that. I believe, based on my training and experience, most officers, once we put that uniform on and we respond to a call, we know that there's a risk factor. We just don't know what level, depending on the severity of the call.
Right. So every single time an officer responds to a call, there is an inherent risk.
Correct.
Right? That's the nature of policing. Right?
Yes, it is.
And an officer, a reasonable officer, has to be prepared for that risk level to change.
Correct. That's where we use tactics.
Now, again, one of the things that officers have to take into consideration is their department's policies, right?
Yes.
And you would agree, would you not, that every single use of force policy that Minneapolis has some form of what's called a qualifier, meaning if it's reasonable, or if it's safe, or if it's tactically proper, right?
Yes.
So all of the analysis has to depend upon.
That's the wiggle room clause in all policy, is because you can't make policy exact for every situation because it changes and you don't know everything, all policy has the escape clause. If it's safe to do so, if it's reasonable to do so, is it reasonably safe to do so within a reasonable amount of time? There's always that wiggle room. So the agency gets to say, okay, yeah, I think that falls into it. But if we don't like you, we don't think that falls into that. It's very interpretive, just like the law.
The safety, the practicality, and in certain circumstances, tactics, right?
In certain circumstances, yes. In most cases, the objective reasonableness of the actual force being used.
Right. And when we look at the use,
See, he doesn't want to come off as a dick to cut this guy off, but this witness knows he's being inappropriate. He's answering a question and then he's adding shit, and he can't do that. That's inappropriate. And the judge ain't stopping him. Prosecution ain't objecting because he knows he's his witness and it's helping him. So they're going to make this guy object, and then it's going to make it look like to the jury, if I shut this guy down, it's going to look like I'm being hostile to him and I don't want him to say something because I'm afraid of what he's going to say. So those are the factors on why people sometimes don't want to object or don't want to do things. When attorneys, some people will say, man, that attorney missed that. He should have done that. There's other factors that the attorney is considering. The jury appeal. Is the judge going to agree with him? Is this something that I want to waste this bullet on, or do I want to save my ammo for something important?
use of force, we don't look at the use of force in a vacuum, do we?
No, we do not. We should not. I've seen some agencies, that's all they focus on is the actual use of force. But when I do my analysis, I look at the totality of the circumstances.
I didn't ask you what you did. I asked if use of force is looked at in a vacuum, and he has turned the question around to where he gets to tell the jury and promote himself on what he did.
Meaning I look at the officer's tactics as well as the subject's actions during the whole entire incident.
Right. And because it's a totality of the circumstances analysis, we need to, and it's objectively reasonable based on the facts of this particular case, correct?
Correct.
And so we need to look very closely at all of the facts in assessing whether or not the use of force was reasonable. Agreed?
I hope he asked this guy, are you familiar with the crime rate in that neighborhood? Are you familiar how many robberies they had? How many calls for service did they have in that neighborhood? Did you put all that in your evaluation on why you came to your conclusion? Because he probably didn't.
Agreed.
So let's talk about the facts of this case. Do you understand that Officer Chauvin was the initial officer dispatched to this call?
Yes.
And that dispatch ultimately, what's called the sector car, took over the call, and Officer Chauvin was no longer responding, right?
Correct. He was no longer the primary unit.
Right. It's reasonable for a police officer to rely upon information he or she receives from dispatch, correct?
Correct.
And so you understand that in this particular case, dispatch advised the officers that the suspect was still on scene, correct?
Correct.
That it was a priority 1 response call, correct?
Correct.
That means get there quick, right? That's code 3, get there with lights and sirens, right?
I don't know the exact code for Minneapolis PD, but I believe you.
Okay. And that the
Priority 1 is the highest priority. There is no higher priority call. Would you agree with that? That should have been his follow-up.
suspect was 6 to 6.5 feet tall, right?
Yes.
And that he was possibly under the influence.
Correct.
Right? So it's reasonable for an officer to rely upon that information in response to a call, right?
Yes.
And
so they can confirm it.
They can confirm it, but it also sets the stage, right? We're talking about the inherent risks,
Yes.
right? So it's much different how a reasonable police officer would respond to an intoxicated, large person versus a smaller person who's just a little
old lady who tripped on the curb and needs medical.
crabby, right?
In some cases, yes. I've seen small people put up bigger fights than bigger people.
So it's reasonable for a police officer to be in a heightened sense of awareness based upon the information they receive from dispatch. Agreed?
Agreed.
Now, ultimately, you understand that under the facts of this case, Officer Chauvin was dispatched a second time, correct?
Correct.
And that's because the dispatcher heard that officers were taking someone out of the car, right?
Yes.
And so let's just kind of stop there for a second. When you consider the fact that this was a forgery or a counterfeiting call, and you don't expect to use force in that type of a situation, you wouldn't normally expect.
Correct.
But now you hear dispatch send you on an emergency basis to the scene because officers are using force, right? They took somebody out of the car.
Taking someone out of the car is not necessarily a use of force.
Have you listened to the dispatch of this, the audio of the dispatch of this case?
I believe so.
And the testimony of the 911 operator was that she heard screaming and scuffling or some sort of a noise that prompted her to dispatch a second car, right?
I didn't hear her testimony.
Okay. But officers, they get the radio traffic, right?
Yes.
They do hear all of the communication amongst all of the officers, right?
Correct.
See, he's getting a little bit of argumentative, not really argumentative, but he's excluding stuff that doesn't help the prosecution. I don't remember. I'm not sure. Well, wait a minute. You wrote a 4,000-page freaking report, and you don't remember reviewing what the dispatcher did, which is a critical part of an officer's response when an officer is dispatched on a priority 1 call, and then he's upgraded to step it up because there's yelling in the background, and the call is the officers have not gone code 4. You didn't review that part of this case? I'd have slammed him.
Right.
And it's reasonable for an officer to rely on that information, right?
Yes.
And if you are an officer and you hear a scuffle on the radio, you hear we're taking one out, and you get dispatched code 3 or in an emergent situation, it's reasonable for an officer to come in with a heightened sense of alertness and awareness.
Absolutely.
And you would expect that, right?
Yes.
You've responded to these calls, I'm sure, thousands of times, right?
Yes.
So now you have an officer, a reasonable officer, would have a heightened sense of concern about this call.
Correct.
I mean, he's doing a pretty good job, but he's kind of letting this, it's almost like he's getting a little worked up because he's kind of fighting with him and he's trying to hold it back, but he's trying to get out all this information to back him in a corner, and it's taken a lot more questions and a lot more explaining in order to get a reasonable answer from this so-called paid expert.
Arrived at 8:17 and 23 seconds. He knew that some degree of force was being used because of what he heard on the dispatch, presumably, correct?
Correct.
He knew that other officers were there, right?
Yes.
He knew that he was being dispatched to back up a situation, right?
Yes.
He knew that the individual suspect was possibly impaired, right?
Yes.
Based on the dispatch. And he knew that he was 6 to 6 feet tall. 6 to 6.5 feet tall.
Yes.
And so when Officer Chauvin arrived on scene, he had a certain amount of information that a reasonable police officer can rely on in forming his or her next steps, right?
Yes.
And when he arrived, he observed Mr. Floyd and 2 officers, correct?
Correct.
At the back seat of a squad car, correct?
Correct.
And what you described as Mr. Floyd actively resisting their attempts to put him into the back seat of the squad car.
Yes.
At that point, according to
That's a really great point, because this goes to the state of mind and reference of the officer when he did it. So he's really painting a good, clear picture. I mean, he'll probably get to it. We'll see.
the model, the use of force continuum, Officer Chauvin, theoretically, based on what he saw, active resistance, he could have come up and dry stunned him or tased him. That would be within the active resistance, struggling use of force continuum.
Yes.
He didn't do that, right?
No, he did not.
Because sometimes an officer has to back down in their use of force, right?
In certain situations, yes.
A reasonable officer who comes on scene based with all of the information that he has at that particular time, right, comes into the scene, sees 2 other police officers struggling with an actively resisting person, right? It's reasonable for that officer to assist his fellow officers in their efforts, right?
Correct.
And you observed the body camera footage of the struggle, right?
Yes, I did.
And you would agree that from the time Officer Chauvin gets on scene into the time that Mr. Floyd is proned on the ground, Mr. Floyd was actively resisting efforts to go into the backseat of the squad car.
Yes, sir.
And the officers were reasonable in their use of force in their attempt to get him into the back of the squad car. Agreed?
Agreed.
I think this would be a good point to make this time, because the defense is really caught up on this 9 minutes and 26-second time frame to get the time that they fought with him from the time of the call to the time he got on the ground, all the active resistance that he was doing.
Things as he was being attempted to be put into the back of the squad car, right?
Yes.
You recall him at that point saying things like, "I'm not a bad guy."
Yes.
Do you remember him saying, "I have COVID"?
Yes.
Or "I just got
I
over
just
the
got
COVID"?
COVID. Yes.
Do you remember him saying at that point, "I can't breathe"?
Yes.
He was saying to the police officers at that point, "I can't breathe,"
Yes.
as he was actively resisting their efforts to put him into the squad car.
Yes.
Now, again, in the course of your career and in the course of your training experience and all of the context that you've done, have you ever had somebody say to you to attempt to bargain with you to avoid being arrested?
Yes.
Sort of like, "Hey man, I'll do what you want as long as I don't have to go to jail," right?
Yes.
Or somebody may be fighting and they may agree to stop fighting with you through a bargaining process, right? Saying, "If I get to sit on the curb, I will stop fighting."
Yes. In certain instances, yes.
Have you ever had a person feign a physical ailment as you attempted to arrest them?
Yes.
Sometimes people will say, "I'm having a heart attack," right? "I think I'm having a heart attack. Don't take me to jail. Take me to the hospital."
Yes.
Right? And it's fair to say that the vast majority, well, I shouldn't say the vast majority, it's fair to say that one of the things that an officer has to do in the assessment of the reasonableness of his use of force is take into consideration what the suspect is saying and how he's acting.
Yes. 100%.
Right? So if somebody is saying, "I can't breathe," and they're passing out and they're not resisting, that's one form of an analysis, right?
Yes.
Because the actions of the suspect are consistent with the verbal utterances he's making, right?
Yes.
Other times, and in this particular case, when Mr. Floyd was initially saying that he couldn't breathe, he was actively resisting arrest.
Initially, when he was in the backseat of the vehicle, yes.
And in fact, he was using his legs to push back and to use his body weight to against the officers, right?
Yes.
And at one point, 3 Minneapolis police officers were attempting to get him into the backseat of the squad car from the passenger side of the car, correct?
Correct.
And they were not able to do so.
No.
And in your report, you described it as when the futility of their efforts became clear, I think was the term you used.
I can't recall using that word, but maybe I did.
All right. Would you disagree? Would it refresh your recollection to review your report?
Yes, absolutely.
May I approach the witness here? The ability of the 3 officers continuing their efforts forcibly to seat Floyd in the squad's backseat became clear, right?
Yes.
So he used a word that he didn't remember using. Wow. Rick, it was a 5,000-page report. Okay.
They put him on the ground in the prone position, right?
Yes.
Saying, a subject, an arrestee is saying, in comparison to their actions, you're also making assessments of their physical characteristics, right? An officer should be observing what physical characteristics a person is displaying. Agreed?
Yes.
So, and you're analyzing that against what a person says, right? Or
Correct.
how they're acting, I should say. So, somebody, if you ask, are you consuming, what did you take? What drugs are you on? And they deny that they're on drugs, but there's physical evidence to suggest to the contrary. It's a consideration an officer has to make, right?
Yes.
And in this case, officers asked Mr. Floyd repeatedly what kind of drugs he was using, right?
Yes.
You've had an opportunity to review the body-worn cameras, and you've seen sort of a white substance forming around Mr. Floyd's mouth.
Yes.
That would be consistent in your experience with someone who's possibly using controlled substances?
Correct.
Is it common in your experience for...
What's he saying is Floyd was lying from the jump street. I'm a good guy. I don't want to resist. I'm claustrophobic. I'm not taking any drugs. Man, I don't want to get in a car. Man, I can't breathe. He was lying throughout the entire contact. Would you agree with that? So why would they suddenly believe him after he fought and it took 3 officers to get him on the ground?
people who have been using drugs or alcohol to deny that they have used drugs or alcohol?
Yes, in some instances, yes.
Right. It's kind of the proverbial drunk driver, right? I haven't had anything, officer, right?
Yes.
I've had 2 beers, right? People have a tendency to minimize what they have consumed, right?
Yes.
Now, you have testified, as I understand your testimony, that once that the officers putting Mr. Floyd into the prone position was initially a reasonable use of force, right?
Yes.
And you're familiar with the swarm technique,
Yes.
where multiple officers are on top of a resisting suspect
Dogpile.
trying to control the extremities, right?
Yes. Typically, that's done prior to handcuffing.
But that's once you're putting someone once someone is handcuffed, right, and they're in the ground, a person who's in handcuffs can continue to be a threat. Agreed?
Yes.
They can kick you.
Correct.
They could bite you.
Correct.
They could thrash and get free and start running, right?
In certain instances, yes.
And in certain instances, they can even get your weapon, right?
Yes.
They could get your gun from you, even though they're handcuffed.
Yes.
So the notion that a handcuffed suspect no longer presents a threat to an officer is not correct.
It depends on the circumstances.
Right. A handcuffed suspect can continue to present a risk.
Based on that person's actions, yes.
Right. And so once you're have a suspect in the prone position and they continue to kick, it may require more force than if they were compliant. Right?
Yes. That's why
And-
we have
and Floyd
devices
did
like the
kick.
huddle.
Right. Now, initially during this instance, you would agree that Mr. Floyd continued to make certain protestations about his inability to breathe, right?
Yes.
And he was saying lots of other things like that he was in pain and that he was hurting, correct?
Correct.
And an officer, a reasonable officer, they need to communicate with each other, right?
Yes.
A reasonable officer is going to rely on information that his fellow officer tells him, right?
Yes.
A reasonable officer, again, is going to take into consideration what the suspect is saying, right?
Yes.
And compare that against the actions, right?
Yes.
I don't know if I'd go a whole lot further with this guy because he keeps throwing different things. I would ask him very close-ended questions. Close-ended
And
means
at a
it's
point-
answered yes or no.
During the exchange, initially, officers are going to kind of talk and figure out what's going to happen next, right?
They should, yes.
What has just happened, right? Why are we involved here? What's going to happen next? And you can sometimes take time to formulate options and decisions, right?
Yes.
In the scene of an arrest, even just in the immediate kind of wingspan, that can be very chaotic, right?
Yes.
People can be talking to each other. People can be talking over each other, right?
Yes.
The suspect may be saying some things, right?
Yes.
Bystanders may be saying some things, right?
Yes.
In the chaos, it's easy to miss some things, right?
In certain instances, yes, depending on the severity of what's going on.
I'd like to publish part of the body-worn camera. It's Officer King's body-worn camera, starting at 20:21:01.
This is a portion of what's already been received.
Yes.
Any objection?
No objection.
I'd like you to see if you can tell me what Mr. Floyd says in this instance.
I didn't Israel. Police. I didn't Israel. Police.
You hear what he said?
No, I can make it out.
Does it sound like he says, I ate too many drugs? Listen again.
I didn't Israel.
Oh, I couldn't tell what he's saying. See, I thought he was making the point. So, if you can't understand what he's saying, and the officers were there hearing all the crowd and looking at other things and evaluating, how could they hear what he's saying? But he's going and said, I ate too many drugs, but nobody heard it.
I can't make that up, no.
So in the chaos of a situation, things can be missed, right?
Yes.
You would agree that at one point during the exchange, Mr. Floyd was advised that he was under arrest, right?
Yes.
In fact, that happened a couple of times, right?
Yes.
Now, at the point they have Mr. Floyd on the ground, you would agree and you're aware that officers called for EMS, right?
Yes.
It's reasonable for an officer to call EMS, right?
Yes.
Depend if there is an injury, right? Or some need.
Or a complaint of injury or some
So again, he's going to, were they acting reasonable? They called for EMS.
discomfort or medical emergency, yes.
And you understand that in this particular instance, very shortly after Mr. Floyd was on the ground, officers called for EMS.
Yes.
They called for
initially for his injury to his head.
To his face, or mouth
Yes.
injury, right? And they called it they called EMS in a non-emergent situation, right?
Correct.
And that happened at 8:19 and 49 seconds. Code 2 EMS for a mouth injury, right?
Yes.
And this occurred at the point when officers were discussing whether or not to use the hobble restraint on Mr. Floyd, right?
Yes.
And
They were being reasonable. They were evaluating. They were trying to determine actions of lower force or how to control the suspect. The reason why they discussed using a hobble is because they were losing control and they didn't want to get him up. And when they got 3 people to hold him still, they were like, you know what? We got him stabilized. Let's not screw it up by trying something else.
And ultimately, officers did not use the hobble restraint, right?
Correct.
A hobble restraint would generally require officers to consider calling EMS, right? According to Minneapolis Police Department policy.
according to Minneapolis Police Department.
And maybe different in other jurisdictions, right?
Correct.
So as officers are discussing and ultimately they decide, you agree, that they decide not to use the hobble device.
Yes, they did not use that hobble device.
And we talked a little bit earlier about the de-escalation component of things,
Yes.
right? A decision to use or to not use a higher form of force that you may have been authorized to use can actually be a de-escalation technique. Agreed?
In certain instances, yes.
Right. So officers making a decision not to increase the level of force can be viewed as a de-escalation technique.
Yes.
Now, again, we've talked a lot about the need for reassessment and kind of things as they reassessment. And officers need to continue to take in information, process it, figure things out, right?
Yes.
They have to, as a part of that process, continue to attempt to de-escalate, right?
Yes.
Would you agree that an officer saying things like relax, take a deep breath, that's a way of trying to calm somebody, right?
Yes, if it's not going with other actions. I mean, you can say relax, calm down, but if you're punching somebody, that's not going to let someone relax and calm down.
Right. But if you have someone restrained and they're complaining, I can't breathe, but they're speaking, they're still moving, they're still talking, you may say, hey man, relax, calm down, take a deep breath, right? We're going to
Yes.
be, right? As a way of reassuring that person, we've gotcha, right?
Yes, that you're listening, or you can understand what they're trying to communicate to you.
And ultimately, again, officers in this reassessment process, in this case, reassessed the need for a quicker EMS response, right?
Yes, after I believe their initial call for the injury, then they asked for a quicker response.
It's stepping it up, I guess, is the quote,
Yes.
right? They increased the priority of the call from a code 2 to a code 3, which in Minneapolis means get here with your lights and sirens, right?
Yes.
As a part of your analysis, again, at any level, did you consider what the average 911 or EMS response time is?
Yes.
Do you have that information?
Not for Minneapolis, no, but I know just on average, typically, usually it's between like 5 to 7 minutes.
Okay. And that's not specific to Minneapolis, right?
Correct.
And it obviously depends upon certain circumstances, right?
Time of day.
If there's say a firehouse 3 blocks away, it may be 90 seconds or
Correct.
a minute even, right?
Correct.
And sometimes if all of the ambulances are busy
Right.
and all of the fire trucks are busy, it could be much longer, right?
Yes. Or
But-
they go to the wrong location.
Yeah, or they go to the wrong location, right? That happens sometimes.
Yes, that's happened to me.
So part of the analysis that a reasonable police officer is making is, I got EMS coming, right? How long should I expect them to be here? How long? They're considering that. They're taking that into their analysis.
Yes, they should.
Now, at the point that they stepped up the analysis, or stepped up EMS to code 3, would you agree that that's about the time that people began to congregate?
I would have to look at the video again, but yes, that's probably around the same time.
Right. So if EMS was stepped up at 20, 21, 8, 21, and 35 seconds, it's about 90 seconds after the initial call, and Miss Frazier is seen coming into the area at 20, 21, and roughly 17 seconds, it's about the same period of time, right?
Is Ms. Frazier the
bystander with the video.
Yeah, oh, okay.
So she's the bystander who started recording.
Okay.
Right? So she started recording at about this same time, right?
Yes.
And she was concerned about what she saw, agreed?
Yes.
And again, based on your review of all of the body cameras, Miss Frazier, she wasn't saying anything initially, right?
I don't believe she was, no.
She was simply there recording,
Yes.
right? She was not in any way interfering with what the police were doing, right?
Right.
But more people started coming together,
Yes.
right? And there was another gentleman that was there before, actually, as they were attempting to put him into the car, right?
The older gentleman, yes.
The older gentleman. And I believe, correct me if I'm wrong, do you participate in a training or present a training or have anything to do with a training called Awful But Lawful or Lawful But Awful, something like that?
Yes.
And so you would agree, the general concept is sometimes the use of force, it looks really bad, right?
Yes.
And sometimes it may be caught on video, right? And it
Yes.
looks bad, right?
Yes.
But it's still lawful.
Yes, based on that department's policies or based on that state's law. That was the whole premise. I did a presentation at a conference for that.
Okay. So the police use of force has a tendency at times to attract observers, right?
Yes.
And in the course of your career, I'm assuming at the very beginning of your career, Not every single person was walking around with a video camera 24 hours a day, 7 days a week with it in their hand, right?
No, but in Los Angeles, it was right after Rodney King, so you did have people walking around with video cameras. There was actually one gentleman that actually was known for doing it.
Right. And so it's become, in the more recent history, as the smartphone has become as prevalent as it is, a more common experience. It's not just one guy driving around looking for cops arresting
Correct.
people. Any single person could be a potential videographer of a police interaction, right?
Yes, it's become pretty common practice.
And in fact, officers themselves now wear cameras, right?
Yes, most.
And in the city of Minneapolis, every uniformed police officer wears a body-worn camera, or they're supposed to, right?
Yes.
And those cameras are supposed to be running when they have interactions with citizens, peaceful or not peaceful, right?
Yes.
There's a limitation to cameras, though, right?
Yes, there is.
The camera only sees what the camera sees, right?
In certain instances, yes.
Meaning anything outside of its field of view is not observable to the camera.
Correct.
And certainly the certainly cameras they don't have a feeling or a sensation, right?
No.
You can't determine what the tension in their body, right, based on a camera.
Specifically, are you
If
referring
someone is struggling, right, and you've got them handcuffed, they can still be tense, but not really look very tense, right?
I would disagree with that.
Okay. So the camera would be able to pick up whether someone is having a particular sensory experience?
Yes, it can.
Okay.
Cyber.
Sidebar.
Please be ready to go at 11:05. Thank you.
Okay, so they're taking a 20-minute break. I'm going to go ahead and end this one here, and because it's an hour and 26 minutes, and we'll go to the next one.